Ukraine Today is joined by the Professor of International Law and the Director of the Department of International Law and International Organizations at the University of Geneva, Mr. Marco Sassòli. Professor Sassòli, welcome to Ukraine Today.
Thank you. Good morning.
Professor Sassòli, first of all, can we start with terminology? You're obviously aware of the events happening in eastern Ukraine for more than a year now. From the standpoint of international law, from the standpoint of international humanitarian law, what it is it a war? Is it a conflict? Is it international conflict, non-international conflict? Can you say your view?
Well, there is certainly an armed conflict. The controversy is whether this is an international armed conflict or a non-international armed conflict. The distinction is it is an international armed conflict if it is between two countries, while it's a non-international armed conflict if it is between the government forces of a country and insurgent forces within this same country. Now, a conflict can be international even if no foreign forces are present, if the so-called insurgents are in reality under the control of a foreign country. So the question is, and this has to be decided upon the facts and not what the parties say, whether either Russian armed forces are present in eastern Ukraine, or whether the insurgent forces are under the control of the Russian Federation. And then it is an international armed conflict.
Well, you're referring to the one of the parties as insurgent forces. There are other people who refer to them as separatists, Russia-backed militants. Ukraine is referring to them as terrorists. So who, in fact, are they?
Well, in law, whether they are terrorists or not does not matter for the applicability of humanitarian law, because unfortunately the amount of violence and the degree of organization of these groups is sufficient to make it an armed conflict. And whether they use terrorist methods or not does not make the law applicable or unapplicable. Simply, it is then a violation of the law.
But is there any legal significance in recognizing the Russia-backed militants as terrorists? Because then, if Russia is supporting these militants, they would be supporting the terrorists.
I mean, if Russia supports even an insurgency in a neighboring country, this is a violation of the principle of non-intervention in international law. Now, indeed, there are some instruments about terrorism, but it doesn't change the fundamental thing. I mean, even if these armed groups do not violate humanitarian law, so for instance, they only attack Ukrainian soldiers and Ukrainian tanks, therefore perfectly in conformity with humanitarian law, nevertheless, it is unlawful to support such insurgents in a neighboring country.
Can we talk a little bit more about the Third Geneva Convention relating to the treatment of the prisoners of war? Does this convention apply to the armed conflict? And if it does apply, are both parties bound by this convention? So even the Russia-backed militants, do they also have to observe the provisions of this convention, assuming, of course, they are aware of the existence of the convention itself?
So the entire Third Geneva Convention and the status and treatment of prisoners of war only applies in international armed conflict. The biggest difference is that in an international armed conflict, a prisoner of war may not be punished for having participated in hostilities, except if he or she committed a war crime, while in non-international armed conflicts, such an immunity of prosecution does not exist.
So basically, all these cases where the Ukrainian soldiers who were captured by Russia-backed militants were paraded on the streets of Donetsk and other cities, when they were tortured, when they were interrogated on camera, does this mean that this is always fine under international law, international humanitarian law?
Not at all. If it is a non-international armed conflict, then torture is certainly prohibited. Under Article 3, it is precisely mentioned as an act which is prohibited, and humiliating and degrading treatment is also prohibited, while the exposure to public curiosity is explicitly mentioned in the Third Geneva Convention as being prohibited concerning prisoners of war. Now, again, it is well possible that Ukrainian soldiers who are in the power of insurgents in eastern Ukraine are prisoners of war. This would be the case if these insurgents are under control of the Russian Federation.
Well, it looks like everything here on the application of the Third Geneva Convention and other rules of international humanitarian law depend on whether this is international armed conflict or whether it is not international armed conflict. So, Professor Solohub, can you give us the guidance? Is there any authority who can decide, even when the conflict is still ongoing, that this is an international armed conflict?
Who could decide? This is a controversy, in my view, mainly about the facts in eastern Ukraine, and both Ukraine and Russia have accepted the jurisdiction of the International Humanitarian Fact-Finding Commission under Article 90 of Protocol 1. So, theoretically, both Ukraine or Russia individually could ask the fact-finding commission to establish the facts. And I must tell you, I am astonished that the Ukrainian authorities do not ask this fact-finding commission to find the facts. Some people say because they are afraid that if they are looking into the facts, they will also find violations by Ukrainian forces. And the Ukrainian authorities do not want to have such violations found.
Professor Sassòli, can you explain a bit more? What is the significance of this fact-finding commission? Presumably, Ukraine refers to this commission. What will be the scope of its work, and what it will be doing, and what will be the outcome?
If one party of an international armed conflict claims that another party has violated humanitarian law, then, and both parties have accepted the jurisdiction of the fact-finding commission. But in our case, both Ukraine and the Russian Federation have made a declaration a long time ago that they accept the jurisdiction of this fact-finding commission. Then each party can ask the fact-finding commission not to condemn crimes or whatever, simply to find the facts, and then to make a report to establish the facts. And this fact-finding commission exists, but I have to be honest with you, it has never worked. And in my view, to my knowledge, it is the first time where it could work on the request of only one party, because you need an international armed conflict, and you need that both parties have accepted. And there are only some 70 states in the world which have accepted. And to my knowledge, until now, since the Fact-Finding Commission exists, there has never been an allegedly international armed conflict between two parties who have accepted this Fact-Finding Commission. Now, obviously, I'm a law professor, so I have to admit that once the Fact-Finding Commission would work, I don't know whether the Russian Federation would accept that or would not simply say this is not an international armed conflict, as they always say. But then it is up to the Fact-Finding Commission, because this is also a question of facts, to find the facts. If one party says I'm in an international armed conflict, and the other one says, I'm not in an international armed conflict, and there are some allegations of violations, like the ones you were mentioning on prisoners of war, which are only violations if it is an international armed conflict. Then the Fact-Finding Commission has jurisdiction to establish the facts.
Yeah, Professor Sassòli, but can you explain what is the significance of the report of this commission? Presumably they do conduct their mission and they produce a report. So what happens next?
So you touch on the weak point of this whole arrangement, and perhaps one of the reasons why the Fact-Finding Commission has not yet been triggered until now. It is, first, the report is confidential, except if both parties accept that it is made public. And second, this Fact-Finding Commission is totally independent and is therefore not within the UN system, for instance, where it would go to the Security Council or something like that. So the result would simply be the parties then have an impartial report about the facts. But there is no world government or world police which will then enforce the findings of the Fact-Finding Commission.
Once this conflict is over, a lot of people, and frankly, I think that a lot of people on both sides will be looking for someone to be brought to responsibility for all the violations of international humanitarian law, among others, which took place, which are now taking place in eastern Ukraine. Who, in your opinion, could be brought to responsibility, and whether there is a possibility of bringing individuals or other entities to international responsibility?
First of all, the International Criminal Court could look into violations on the territory of Ukraine if Ukraine was becoming a party to the statute of the International Criminal Court. Ukraine has made a declaration which has subject some events, but also only the famous Maidan events, to the jurisdiction of the International Criminal Court. So, because both Ukraine and Russia are not party to the International Criminal Court statute, only the Security Council could hand it over to the International Criminal Court, and this will not happen. You know why.
So basically, because Ukraine has not ratified the Rome Statute of the International Criminal Court, the war crimes which are now happening in eastern Ukraine cannot be tried internationally, but only locally.
Exactly, but also locally in third states, as far as it is about international crimes. And I must stress that it is not too late for Ukraine, because Ukraine could make a declaration. It could say all events which happened since February last year are subject, on the territory of Ukraine, are subject to the jurisdiction of the International Criminal Court, which would mean that everyone who on Ukrainian territory, and under international law this includes Crimea, has committed a war crime, would be subject to the jurisdiction of the International Criminal Court.
From your experience, how easy it would be, assuming Ukraine ratifies the statute of International Criminal Court and passes the jurisdiction of the crimes being committed now in eastern Ukraine to the ICC, how easy it would be for the ICC to try these individuals?
It will be difficult. Because obviously the International Criminal Court does not have police, so it cannot go to Donetsk except if the people who control Donetsk let it come there. It has no right to go to Russia because Russia is not a party, so it could only work on Ukrainian territory. And obviously, it is very difficult to establish criminal responsibility. And again, the Russian Federation has no obligation to cooperate because it's not a party to the statute. So Ukraine would have an obligation to cooperate. And as far as the insurgents in eastern Ukraine are concerned, they count from a point of view of international law as Ukraine. So the International Criminal Court would have the right to inquire with them, to ask Ukraine to arrest them. But as there is an armed conflict, Ukraine is not able to arrest them.
And as well, looks like Ukraine is in a very difficult and tricky situation in this regard as well. Professor Sassòli, many thanks for finding the time to talk to us. This was Volodymyr Solohub for Ukraine Today, together with Professor of International Law and Director of the Department of International Law and International Organizations of Geneva University, Professor Marco Sassòli. Thank you for watching us.